Hey there. Today I want to tell you about a case that we are working on about vaccine passports in British Columbia. If you have been subscribed to this channel for a while, you will already know about this case. I have a lot of videos about it, which I will link to below. Well, tomorrow is the appeal. I'm heading to British Columbia right after this video. Send me some good travel vibes. And you may not be surprised to hear that once again, the government is trying to stop this case from even being heard. Well, it is happening, and I can't wait to tell you all about it. If you're new here, welcome. My name is Christine, and I'm the litigation director for the Canadian Constitution Foundation, a legal charity that fights for fundamental freedoms in Canada. I upload regular videos about our ongoing cases and about other interesting developments in constitutional law in Canada. So if that sounds like something you'd be interested in, hit like and subscribe below. It really helps my videos out a lot. Also, please remember, nothing in my videos is ever legal advice. If you have your own legal question or problem, consult your own lawyer. So this case in British Columbia is about vaccine passports. And, I was thinking about it, and it's so surreal to reflect back on this time in the not so distant past and recall that we were once forced to show government issued QR codes to de facto bouncers at restaurants, libraries, and movie theaters, disclosing whether or not we had received a particular medication. And during the pandemic era, COVID-19 vaccine passports that were required by governments, they changed how society functioned. And in a lot of cases, these vaccine passports, the way they worked, it was constitutionally suspect. In particular, the policy in British Columbia was really troubling because it failed to provide for open categories for medical exemptions. I know that maybe it's more comfortable to forget this period of our lives, but for the sake of people who had their rights violated, we can't forget it. Now, citizens who couldn't obtain good faith medical exemptions in BC are now going to be having their day in court starting tomorrow, and the Court of Appeal is going to be hearing our appeal of a decision that dismissed an earlier challenge to the vaccine passports. And we brought this challenge along with 3 women who had been directly impacted. If you want to hear more about their particular stories, I talk about them a lot in detail in some of my other videos, so I will link to them below. Go and check them out. And also, I discuss them in detail in an article I wrote for C2C magazine, which I'll also link to. And I give even more detail in my book, Pandemic Panic, which you can order on Amazon right now. Please do me a personal favor, go and order that book. It would really mean a lot to me, and it really helps us out a lot. So the 3 women in our case, they were ineligible for medical exemptions on the face of the law. The BC government used what we describe as a closed list for medical exemptions. Only people with specific and named conditions that went alongside particular checkboxes, only those people were even allowed to apply for a medical exemption. And the conditions included things like heart inflammation, pericarditis that developed following a first dose of a COVID vaccine. It included people undergoing certain types of cancer treatments and people who had anaphylactic allergies to components of the vaccine. But 2 of the patients that we were working directly with had rare medical conditions and complex medical histories that were not listed on that mandatory exemption form. They were too uncommon to have even been contemplated by the government. So they were ineligible even to apply. And even though one of our patients did have one of those listed conditions, she had pericarditis, she was still only potentially eligible for what is called an activity by activity exemption. That meant every time that this young woman wanted to do some basic socializing in a public place, she needed to apply to the government for an exemption for that specific activity. Unfortunately, at the lower court level, the cases were dismissed as premature. Apparently, the court agreed that these patients should have known that the government was secretly actually issuing medical exemptions for conditions beyond those on that closed list, and that these patients should have known that the government wasn't actually enforcing the activity by activity application requirement, even though that was what the law said. Essentially, the government successfully defended unconstitutional orders by saying that they secretly didn't actually follow them, and then faulted these women for not having known this. So that's the decision that is now being appealed, but the government has thrown up yet another procedural roadblock. They are claiming that the case is moot. Now, the government had already unsuccessfully argued that the case was moot at the lower level, and they're now attempting to relitigate that position, which they really are not supposed to do. But if the government succeeds in claiming mootness, they will once again evade scrutiny for their illegal law and deny justice for victims of government overreach. But beyond this, the simple fact is that the case isn't moot. The BC government has refused to commit that they will not bring back some form of vaccine passport. And as we're entering the fall season where respiratory viruses seem to peak, it's a realistic prospect that this type of policy could return. The BC government has also maintained vaccine mandates in certain contexts, namely for healthcare workers. And to be clear, that's a new government mandate. It's different from pre-existing employer mandates that have a longer and different history. So our position is that there's no reason for the Court of Appeal to reach any different conclusion on mootness that the lower court did. And even beyond that, the case has broader ramifications in addition to the charter impacts on these three women. The government claims to have used this secret and unknowable process to remedy a constitutionally suspect law. That type of approach cannot be permitted to stand. Just imagine how that type of secret process solution may be used to evade constitutional review in other cases. This case has precedential weight from an administrative law perspective, in addition to its weight addressing the discrimination and security of person arguments of these directly impacted three women. This hearing is going to be taking place over the next 3 days in downtown Vancouver, and the outcome is going to be watched closely by civil libertarians like myself and others at other organizations. The COVID-19 pandemic was novel, it was unprecedented. But we can't avoid learning crucial lessons from that crisis by closing our eyes to rights violations on procedural grounds. I'm going to be doing videos each day following the hearings to summarize what happened for those of you who are interested but can't attend. Those videos are going to go live on October 4th, 5th, and 6th, so turn on your notification bell so you get a heads up when I am about to go live. If you can't make it to the live stream, that's totally cool. You can always re-watch them later on this channel. Hit subscribe so you know when they've been posted. And if you want to get more updates, you can subscribe to our email freedom updates at the ccf.ca/freedom updates, where I'll provide more information about the cases. And as I mentioned, if you want to learn more about this case and other cases related to the pandemic, buy my new book, Pandemic Panic, which is available on Amazon right now. I've got a link in the description below. Okay, that's all for this update. Thanks for watching, and let's keep fighting for freedom in Canada.